I wanted to find out from you, Cilna. We've got a lot of clients in the property sector who will at some point or the other, attempt to bring an urgent application. And that's, I think it's something important for us to know. What is an urgent application? When would you have grounds to bring an urgent application? And where can that urgent application be heard? And the reason I say this, where can it be heard, is because this is the case I was referring to. We had a judge who I think pre-COVID had held an urgent application at a spur, which is a very weird location, but I wouldn't complain. I mean, the Cheddar steaks are to die for. So if I can get my judgment handed down and a Cheddar steak, that's a win-win. So now, what do you have to say about this?
Well, Chris, I'm just saying potential loss in a court case could be a deal sweetener if you can, at least swallow that down with a spur milkshake. So I suppose that could make sense. But it's actually very cool. I think what's important to consider in this particular case, the fact that it got a lot of media attention right now isn't because it happened now. It's during the judges' interviews. And I've watched a few of the interviews, and I actually think it's important for our viewers and for the general public to watch those interviews, because you get a very good idea of what our bench is like. I'm diverting from the question massively. I'm sorry, but I do that. I recently had a conversation with a friend at a braai, and he had a few negative things to say about our bench and our judges and things. And I said, well, the thing is, how many times have you been in a court? And the answer was obviously not even once. And I said, okay, so your opinion about our bench and our judges is exclusively based on the negative things that you see on social media. Every single time we have a matter in court, which is a few times a day, my stomach turns knowing that we have to make sure every single legal box is ticked to a whole new level. I don't think the public appreciates the kind of quality judges that we have on our benches. You will lose an eviction where all the facts are, well, not us now, obviously, in this conversation, but other attorneys might be unsuccessful with an eviction and not get the order because you didn't follow the process perfectly. 10 court days, 14 calendar days. You need to follow those things perfectly. Otherwise, you will simply not get your order, even if your facts are stacked in your favor. So I think this is actually a very cool conversation to have, because I think our judges get a massively bad rap, but mostly because people don't go to court and they don't understand what we are doing in court and don't understand the legal technicalities. And I can really say our judges are magnificently brilliant. Obviously, you're going to run into an acting judge that might not be comfortable with the specific topic that you are approaching him on. But that's your job as the attorney or the advocate, to then enlighten the judge and give him case law and give him direction to hand down the order that you want. So I went on a tangent now purposefully, because I think nobody explains this to the rest of the country often enough. These interviews are massively entertaining, and some of the candidates, I must say, if they do end up on the bench, I would be a little concerned. But this particular matter doesn't, I don't really have an opinion about this per se, but what I can say is the event of this judge saying, I don't want to drive into town now to go and hear the matter. I'm going to hear it at a spur close to me. This is not a lazy judge, guys. If you haven't been to one of our courts, especially Pretoria and Joburg, I don't think you would appreciate why you wouldn't want to drive there in the evening. I avoid the city with everything I have, especially for a woman, and this is a female judge. I would have avoided going to court as well. So I'm not making a call on the judge's decision here, but what I'm saying is let's just give a little bit of perspective to the story. An urgent matter is something very important. And I think it's very important for people to understand how urgent applications work. Urgency isn't you want an order quickly. That's not why the urgent process is there, because I can tell you, Bruno, have you ever had a client that said, you know what, I'm cool, we can run this matter calmly, I'm not rushed? No, whether it's something pleasant like property transfer or a divorce, or something unpleasant like an eviction, everybody's rushed, and everybody's matters are the most important. Why? Because we're all the, stars in our own movies. Obviously, the whole world should stop and give you your order quickly. It's your matter. And that's unfortunately not how urgent court works. So in terms of the uniform court rules, so the rules regulating only the high courts, it's specifically rule 6. And it's very weird that I can pull a court rule like that, because I don't know the court rules as well as I know legislation. So the fact that I know this rule number means this is a very important rule.
I think everyone knows 612.
That's him. That's the only one we know. So it's a very important rule that sets out the rules for us on when a matter is urgent. And the truth is, the starting point on when a matter is urgent is if the order is not handed down now in a certain time period, it will cause irreparable harm. Irreparable harm is not commercial harm. To lose money is not irreparable in the court's eyes. We know practically that once you have a court order to collect money, if the person doesn't have money, you can't collect that money. So that is pretty much irreparable, but unfortunately, it's not factually irreparable. It's not objectively irreparable harm. So to bring an urgent eviction, for instance, is almost impossible. An urgent residential eviction, unless, like in a case that it was done on an urgent basis, Schubert Park, that I can't even remember. It feels recent, but Bruno, now that I think back on it, it must have been pre-2010, and in my head, it's like yesterday. So the Schubert Park eviction, I'll tell about, because that was one of the only matters where the court was satisfied to hear a full eviction on an urgent basis. And the reason for that was the foundation of the building started to collapse. So the building, there was a risk of the whole building collapsing with these people in the property. So listen to those facts. It's not irreparable financial harm to the owner of the property. It was actual physical bodily harm or death of the occupants, the illegal occupants. And this is the only reason why the court heard it on an urgent basis. It's not unfair. It's because the obvious immediate thing that people think is, oh, but that's unfair. And now the court favors the respondents, the illegal occupants. But if it's the owner that wants to go on urgency, it's not going to be successful. That's not what happened there. Urgent court must be reserved for urgent matters. And you get levels of urgency. We always call the Friday urgent court, the old people and children court. And I'm going to say it because that's the public, that we all know this. And the reason why Friday court, urgent court, is very special, Friday, Saturday, Sunday urgent court, unless somebody is about to die or is about to be a kid that's about to be taken abroad by one of the parents in a maintenance battle or something like that. Those things are urgent enough where the judge will hear that in his slippers, wherever. But usually we don't get a lot of those matters. Those are the matters where you file your papers, you give 15 minutes for your for your notice of intention to oppose, you give half an hour for an answering affidavit. It's crappily drafted. It's not pretty. You basically just argue and tell the judge the story, and the judge has to make a very quick decision. That's extreme urgent court. And like I said, it's usually reserved for life or death situations, or a situation where a child is going to suffer irreparable harm if the court doesn't intervene on a very urgent basis. Then we have medium urgent matters, where if we can't wait for next week, we need to hear it today. For instance, somebody disconnects somebody's utility supply. And I feel like that's going to be a topic for today. So where somebody can disconnected utility supply, the illegal occupant, is usually the person with the non-utility supply, approaches the court. That's not extreme urgency. That's not so extreme that the judge has to hear the matter in his slippers. This is a matter where if you sit down on Thursday, you will be heard on Tuesday, and that's usually how our urgent courts run. Well, at least South-Gauteng, sit down Thursday to be heard on Tuesday. That gives everybody enough time to file their papers, but it's quick. It's very quick. It's very expensive. The reason why it's very expensive is we, as the attorneys, have to work through the night, and we have to draft, and we have to perfect our documents, because you can't go to a court with bad spacing and horrible font and a document that doesn't look clear, even though it's on urgency. So we work very hard, very fast. And if you have an attorney in your life, you will know when an urgent hits and they say the words, "I have an urgent," you just stand back and bring the coffee. That's the only thing you should be doing. It's a very intense, very stressful thing. And the courts are brutal, because if you do not have urgency, that's where we start. If you can't convince the court that this matter is urgent and it's going to cause irreparable harm unless it's heard right now, you're going to be blown out of the water, and you're going to have a very harsh cost order against you, because you just pulled the judge away from his survivor bench watching in his slippers, and he is not loving you right now. And then we have urgency that's not that extreme, where it could be a month. So say, for instance, we know somebody has terminal cancer, but it's not a right now problem. This person is going to struggle with cancer for a year. And if we can bring us an eviction application, this person can take occupation of the property, and they don't have to rent another place, or they have financial relief to take care of themselves while they go through this very unfortunate cancer journey. Then the court will say, okay, it's not extremely urgent, it's not medium urgent, but it's sort of urgent. So instead of going through the 2-3 months process for an eviction, we bring the timelines in a little, and we just reduce the timelines a little. So urgent court is usually heard currently virtually. And I think that's the massive difference between this judge's matter and any other urgent application. All our matters are anyway currently being heard virtually. So even our normal motion roll is heard virtually. So if you're in a court that doesn't do that, for instance, I know a few of the courts still really prefer open court, and they don't do it virtually. You can actually, especially on an urgent application, apply to court to have the matter heard over Teams. The court specifically use Microsoft Teams. So then all the parties join over Teams, and that's fine. But you cannot hear a matter outside of open court. A judge may not even hand down judgment in chambers. It must be handed down in open court. And open court means it's a court, there's a bench, and there are people that can come in and out. If it's virtually, it means there's a link being sent, and all the parties that's relevant to this can join the court. Currently in virtual court, we even have a gallery. So you are allowed to join in the gallery, and currently in virtual court, we do have a setup in the actual court building as well. So if you don't have internet access or something like that, you can go to court and actually attend to court. So unfortunately, for this judge, it isn't proper at that time to hear matter in spur. It won't be proper now even, but it will be proper to have the matter heard virtually.